right.
Okay, so let's be on the record in case number 2020-CR640, captioned State of Kansas versus Brian Cobb. Would the parties announce their appearances, please?
May it please the court, Karen Whitman for the state.
Good morning, Your Honor. Mr. Cobb appears by Zoom with counsel Adam Stolte by Zoom.
All right, we are here set down for a plea. My understanding in visiting with counsel today that this charge is going to be amended to a first-time DUI, which is a Class B misdemeanor. The defendant will be entering a plea to that charge, and the parties will be waiving pre-sentence investigation going forward with sentencing today. Is that correct, Ms. Whitman?
That is correct, Judge.
And Mr. Stolte?
Yes, Judge. Thank you.
All right. Well, sir, I just have to ask you some questions to take up your plea today. As you sit here today, are you under the influence of any alcohol, drugs, or prescription medicine that might keep you from understanding what we're doing today?
No, sir.
Feel like your mind is clear?
Mine's clear. Yes, sir.
All right. Do you know what you're charged with?
Yes, sir.
You know you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial in this case. You understand that?
Yes, sir.
All right. The state would have to prove you guilty beyond a reasonable doubt. You would not have to prove anything yourself. Mr. Stolte would be able to help you throughout that trial. He could cross-examine and confront all of the state's witnesses, challenge their evidence, call any witnesses you wanted called. At that trial, you could testify, but you'd also have a right not to testify. And if you decided not to take the stand, that couldn't be used against you. Do you understand all those rights?
Yes, sir.
All right. And if you had that trial and were convicted, you'd have a right to appeal it to the Kansas appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes, sir.
If we do this plea today, you're going to be giving up all of those rights. There's not going to be a trial of any kind in this case. Do you understand that?
Yes, sir.
All right. Now there's an agreement by the parties for a particular sentence, and that basically involves probation, a minimum jail time, which it looks like you've already served, and a minimum fine. I'm going to listen very closely to all of those recommendations, but you understand that I'm not bound by them or a party to them, and I can give you any sentence that the law allows me to. Do you understand that?
Yes, sir.
The maximum that anybody could get for this case would be 6 months in jail and a fine of $1,000. Do you understand those are the maximum penalties?
Yes, sir.
Okay. Any questions about anything we talked about today, Mr. Cobb?
No, sir.
All right. And knowing all this, you still want to go forward with this plea?
Yes, sir.
All right. I would note for the record, before we go any further, that the state has forwarded to me a copy of the evaluation that the defendant has undergone for substance abuse. I'm going to mark it Defendant's Exhibit A. Any objection to that being received?
No objection, Judge.
No, Judge.
All right. Given all that, Mr. Cobb, as to the amended count, which charges you with DUI, first offense, a Class B misdemeanor, how do you plead? Guilty or not guilty?
Guilty.
All right. I'm going to ask the prosecutor to tell me what she thinks the evidence at trial would be. I want you to listen closely because when she's done, I'm going to ask you if that's what happened, okay?
Yes, sir.
Ms. Whitman.
Judge, it's the state's understanding the defendant will plead to the count 1 of DUI first offense on the second amended information. The state will, for that plea, dismiss all the other charges. Sentencing will be 6 months, suspend all but 2 days. It's the state's understanding the defendant has already completed the minimum mandatory sentence. Fine of $750, court cost of $108. There's a probation fee of $60. There will be 12 months probation with court services. He must attend a MAD impact panel within 60 days of release from the jail. He must
Ms. Whitman,
get.
if I can stop you. I was asking for a factual basis for the plea.
Oh, I'm sorry, Judge.
That's okay.
Okay. The factual basis is on September 11th of 2020. Officers with KU Medical Center were dispatched to a crash that occurred on 36th Avenue and Rainbow, where a vehicle had crashed into a southeast utility pole at that intersection. Upon arrival, they came in contact with an individual. They reviewed some video and determined that Brian Cobb was the driver. He admitted to consuming alcohol and crashing into the pole. They did some standardized field sobriety tests, determined that he was impaired. They placed him under arrest. They read in the advisories, asked if he would take a breath test. He stated they would take the test, and the test indicated a 0.187. All these events occurred in Wyandotte County, Kansas.
All right. Mr. Cobb, did you hear what the prosecutor had to say?
You
I'm
cut
sorry,
out
I may-
just
I
a
may
little
have
bit.
cut out there. Did you hear what the prosecutor had to say?
Yes, sir.
Is that what happened?
Yes, sir.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently changed his plea from not guilty to guilty. He understands the nature of the charges and the consequences of the plea. There has been a sufficient factual basis provided by the state for a finding of guilt. The defendant has acknowledged that factual basis. I therefore will find that he is guilty of first-time DUI, a Class B non-person misdemeanor. Pursuant to the plea agreement, the other charges are dismissed. The parties are waiving pre-sentence investigation and asking to go forward with with sentencing today. Given that, Ms. Whitman, I would ask for your comments as to sentencing.
Judge, I ask that you follow the plea agreement that I spelled out. He should follow the recommendations of the evaluation that he has obtained. He would be on probation for 12 months with court services. I would ask that he cannot drive unless he's properly licensed and insured, cannot drink. And I also spoke with the defense attorney earlier about ignition interlock. Clearly, if he does drive, I would like him to have that device in his vehicle. That's my request.
It is not mandatory for a first-time DUI, correct? Okay.
Right.
All right, thank you. Mr. Stolte, comments?
Judge, we agree with the recommendations from the state. The only clarification would be that he does work construction, so he will occasionally drive his boss's car, but he will not do that unless he is properly licensed and follows through with the recommendations of the Kansas Department of Revenue.
Thank you. All right, Mr. Cobb, anything you want to tell me in mitigation of your sentence today?
No, sir.
All right. I am going to follow the plea agreement. I'm going to order that Mr. Cobb be given a 6-month underlying jail sentence. All of that except the 48 hours that is required under the statute will be suspended, and the court will find that the defendant has satisfied that requirement before sentencing. He will be fined the mandatory minimum amount of $750, and he is granted probation to adult court services for a period of 12 months. Specific terms of that probation will be that he follow the recommendations contained in the evaluation, which was marked and admitted today as Defendant's Exhibit A, that he not ingest alcohol or illegal drugs. If he has prescription medicine, he needs to share that information with his probation officer so that those can be monitored as well. He is to complete a MAD impact panel. He is not to drive unless he is fully licensed and insured. Mr. Stolte, does your client own a personal vehicle?
Yes, Judge.
All right. If he drives that vehicle during the period of his probation, it shall be equipped with ignition interlock. if driving his employer's vehicle during work hours or for work purposes, I will not require that it be equipped with the ignition interlock. Okay. Ms. Whitman, things that I've failed to cover in our sentencing today.
I think you got everything, Judge.
Mr. Stolte,
Judge, I don't think my client's going to like this, but I did not hear the $108 fee and then the $60 fee.
I'm sorry, all of those mandatory fees and costs are assessed, including the misdemeanor court cost, supervision fee, the required ADSAP fee. I'm not sure am I missing any additional fees?
I don't think so,
Just-
Judge. It was just
Okay.
Yeah, the
two.
60,
All right.
yeah, probation fee. Yeah, those are it. Yes.
All of those are assessed. Mr. Cobb, it sounds like you're working. If I were to order you to pay, say, $75 a month at a minimum, that would probably get you paid off before your probation expired. Would that be something you would be able to do?
I can pay it in full, Your Honor.
I didn't understand that.
So, yeah, just say that.
Yes,
Okay.
He'll take the $75 a month plan, but it sounds like he thinks that he can get that paid off in full very soon.
Great. That will work. All right. Other things for our record today, Ms. Whitman?
The only thing is, Judge, does he have the phone number to get over to probation?
Yeah, we'll do that when we get off the record here so I can
Okay, thank you.
stop our live stream. Mr. Stolte, anything else we need for our record today?